Hello, everybody. This is the More Perfect Union coming at you on a tape delay with a special guest interview of Supreme Court Justice candidate for the state of Wisconsin, Daniel Kelly. Daniel Kelly, welcome to the show.
Mike, thanks so much for having me on your show. I really appreciate this.
For the people that may not know you, you have been a Supreme Court justice, you've been a judge, you've been a lawyer for many, many, many years. Can you give us a little bit of rundown?
Sure. So I've spent most of my career at one of the oldest and largest law firms in the state of Wisconsin, practicing commercial litigation, but also having a significant piece of constitutional litigation as well, protecting our constitutional rights. And so I was appointed to the Wisconsin Supreme Court by Governor Walker back in 2016. And Mike, I got to tell you, that has been the greatest honor and pleasure of a professional lifetime. Now, I have to qualify that because the greatest honor of the lifetime was convincing my wife to marry me, and I'm still grateful that she decided to do that. But beyond that, this has just been an honor to serve the people of Wisconsin on their Supreme Court, and it is service, right? So this gets to the really important relationship between the people of Wisconsin and those who are in state office, and it's the relationship between boss and servant. And I know that I'm not the boss. So I fell in love with the people of Wisconsin 40 years ago when I first came to Wisconsin to study at Carroll College. And before that, I had not been here ever, didn't know a soul in Wisconsin. But because of the very first people I met on the very first day I arrived here, I just fell in love with the people of Wisconsin. I learned that they are the people of the open heart and generous hand. And it has been that way ever since. And that's one of the reasons why it was such an honor and a privilege to serve them on the Supreme Court.
Thank you very much for that. You know, it's there's a lot of talk that that the Supreme Court race is a nonpartisan account, but what we generally see is there's an ideological tilt or judicial philosophy tilt, if you will, on the court. I noticed on Janet Protasiewicz, as your opponent's website, or a website that's supporting her, that among her supporters are actively listed people that are actually sitting on the Supreme Court presently. What is the effect? What is the effect of this in terms of polarization? And if you're elected, how can we get to a judicial philosophy that is less polarizing and more inclusive of helping people understand what the role of the court is in our constitutional republic?
Yeah,
And in this case, for Wisconsin.
sure. So I think the place to start is to recognize that the court is not there to do politics at all. In fact, politics are poison to the work of the court. The court is a legal institution. All we do there is decide legal questions. So we have an entirely different branch of government to address the political questions. We call it the legislature. And so that's where we really start out with the fundamental difference between my opponent and me. So as you might have noticed, she's been going around the state of Wisconsin and she's talking about nothing but her politics. And that's a problem because it betrays what she would want to do if she made it to the Supreme Court. So the stark decision before us is whether we're going to have the rule of law or the rule of Janet. And that is the difference between judicial philosophies, right? So I have actually a judicial philosophy. She has a political philosophy, which means that she's campaigning as a politician who dresses like a judge, but who isn't really a judge. So I look to our Constitution to understand what the people of Wisconsin have commanded us to do in the judiciary. And what I see there is really quite clear. They've told us they have one job for us. And they say, pay attention, do this one thing, do it really well, but it is just one job. And that is to use the existing law to decide cases that come before the court. So they tell us they're not interested in what we think about the laws, whether we think they're wise or effective. They tell us that they have an entirely different branch of government to address those questions. And of course, that's the legislature. So the difference between my opponent and I, as you listen to the way we campaign, I talk about things that are necessary for a jurist to know and understand: the Constitution, the rule of law, judicial philosophy, what it takes to be a good jurist, while my opponent talks about nothing but her politics. Now, that would be fine if she was running for the legislature, but near as I can tell, she wants to run for the court. So at some point, I hope she starts talking about things that are relevant to what the court does.
Thank you for that. So, justices and judges and justices, really, since most notably from Ruth Bader Ginsburg forward, have all talked about the need to, not give any hints, no prognostications, and things like that. A
Yeah.
lot of people, on the conservative side would really like you to talk about how you would rule in specific cases.
Mhm.
And I think that I know that the RBG rule, I subscribe to it. I don't think a justice or a judge candidate should lead into where they're going. They should be governed by the law, as you have so rightly indicated. But we know that historically courts, and I'll use Supreme Court precedents because they come to mind easiest for me, but court cases like Plessy versus Ferguson or Dred Scott, the court gets it wrong occasionally.
That's right.
um, and then there's the nature of how a lot of court cases have been decided particularly since 1900. Before that, it was mostly canon law, common law types of things, Old English law, as it worked through the Constitution. With the rise of the administrative state, things have become more inferred. We start seeing the concepts of substantive rights and things of that nature. What do you think, without having to give away how you would vote on any kind of a case, what do you see as the big problem with looking at things that are concrete, defined rights versus the implied or the substantive rights that we see in a lot of court cases today?
Yeah, so I think that goes to really what the fundamental responsibility of a jurist is. So I refer to my judicial philosophy either as constitutionalism or as constitutional conservatism. Now, that doesn't have anything to do with politics. So when I say constitutional conservatism, what I'm referring to is conserving the original public meaning of our constitutions. So this goes to what the job of a justice is, and the question of whether law has a fixed and defined and ascertainable meaning. And I, of course, believe that it does. When the framers wrote the Constitution and proposed it to the states for ratification, each of those provisions had an understandable meaning. And that was the intent behind the framers, is to have an understandable meaning. So when they proposed that to folks all across the states at the time, they would have the ability to consider the document they created and how the Constitution would create the government, how that government would function pursuant to that document. And so it was a conversation between the framers and those who were asked to adopt it. And to do that, you have to have fixed and definable meaning in the law. And so every time that we go back to look at legal texts, we have an understanding, those of us who subscribe to a constitutionalist theory, we have an understanding that at the time those texts were adopted, it did have a fixed and ascertainable meaning. And that's what we're trying to figure out. What was that meaning? And then we use that meaning to decide the cases in front of us. Now, there's a competing school of thought called many things, but most often living constitutionalism. And the idea there is that societies change over time and constitutions don't. They still mean the same thing they did when they were adopted. And in living constitutionalism, the judge believes that he can put himself above the law and that he or she would actually have the authority to change that document without asking permission from the people of Wisconsin or the people of the United States, and pretend as if it says something today that it did not say when it was adopted. Now, of course, that's a problem because it destroys the very concept of the rule of law. And that concept is very pretty straightforward. It's the promise that we can know in advance what the law requires of us, so that those of us who wish to live our lives according to the law can check on what it requires or forbids, and then make our decisions accordingly. But living constitutionalism sets all of that to the side and says you can never really know what the law says until a judge tells you in a case in which you're involved what it says. So that destroys the concept of justice. It robs us of the rule of law and our ability to make choices in a way that conforms with the law. So those are really the competing judicial philosophies. One is very creative and expansive and uses authority that is not delegated to them by the people of Wisconsin or the people of the United States. It puts the jurists above the law, which is problematic because our entire form of government depends entirely on everyone being subject to the law. And that goes especially true for those who are in government. So constitutionalism, the judicial philosophy to which I subscribe, says those documents, whether statutes or constitutions, they mean the same thing today as the day that they were written, to the extent they have not been changed, right? So both the United States Constitution and the Wisconsin Constitution can change over time, but there's a specific process you go through to do that. So with the United States Constitution's Article 5, Wisconsin Constitution's Article 12, and that tells you how to amend that document. And that I've looked at both of those real carefully, Mike, to see if there's any role that the courts can have in that. And what I've found is that the people of the United States and the people of Wisconsin have said there is no role at all for the court in updating those documents. They've reserved that right to themselves in conversation with their legislatures. And so the way I approach these cases is always going to be to discover the original public meaning of the legal texts that are applicable to the case that we're deciding.
One of the to bring a case up that is in the relatively recent past, but I'm not trying to relitigate it, but the whole Donald Trump election cycle 2020 and the retort that a lot of people on one side of the political aisle said that, you know, every case was thrown out, every case was thrown out. That's not really truly the case. Those cases in most of the time weren't actually heard on their merits. They were released by, or they were dismissed or discharged by a concept known as applying latches. And latches is, in a generic term, and you can explain it probably in a lot more detail than I can, but essentially it's like Katie bar the door. You can't bring a case so far after an event that it causes harm to the potential respondent or defendant in a case. And in election law cases, it's a little bizarre because you're not actually harmed until the election has taken place. And then after the election's taken place, then a lot of the courts, most of the courts said that you should have acted beforehand. But you can't generally, in a civil claim, which is what these, I think, ostensibly were, you can't bring a cause of action without actually showing harm. So talk about, and I know the courts in election cases have usually had a fair amount of discretion in being able to choose whether or not they would apply latches. How does the concept of latches, do you think, could it have been misapplied in a lot of these cases? Should the people have had the right to actually hear the merits of those cases and just go through, in essence, should many of the courts have actually used better discretion when talking about the application of latches in those cases?
Yeah, so election litigation has some peculiarities that require really quick action if there's going to be any legal remedy. So the way latches works is, as you described, one aspect of that is looking at the harm that it would cause to the other party if you bring the cause of action too late. But there's also another aspect to that, and it's whether or not the case could actually provide the relief that's requested. So one of the reasons why election litigation has to happen so quickly is because of the different jurisdictions that we have in play. So as you know, when we have a presidential election, we actually have 50 separate elections because there is no national election. We have an election here in Wisconsin, There's one in California, there's one in Oklahoma, and so on, all through all the states. And the idea there is, and you're actually not even voting for president, you are voting for presidential electors. And then those electors vote in what's known as the Electoral College. So when we have the election here in Wisconsin, what we have to figure out is which slate of electors was actually chosen by the people of Wisconsin. And there's a process that we go through to do that. So we choose it by popular election, and then the results go through a certification process, and it starts at the ward level, and it goes all the way up to the state level. And once the state certification is done, then that determines which slate of electors will participate in the Electoral College. Now, here's where the two different jurisdictions come into play. So, those the results of the state certified elections will be transmitted to the federal government. So, as you know, there's the joint session of Congress in which they receive the electoral votes from each of the states, and then they count and verify those votes to determine who was elected president. But that's outside of the jurisdiction of the state of Wisconsin. So as soon as that process reaches the federal level, there's really nothing that the state of Wisconsin can do to affect that anymore, because the process has moved outside our jurisdiction. So if there's to be a judicial change to the slate of electors, if someone alleges that fraud affected the results, or there was some other irregularity in which the certified slate of electors were legally incorrect, that has to be taken care of before the federal government gets involved in the process in that joint session of Congress. But once that takes place, then there's no longer any opportunity for the state to say anything meaningful about the process, because the votes have left the jurisdiction of the state.
Okay. Yeah, and I think a lot of people feel that almost like they didn't get their fair shot opportunity, and that the door was closed on them. And I think it's important to understand what Latches really means, and how important it is to actually do more to elect people of your political persuasion before you ever get to those presidential elections. It's the state and local elections that mean more to the average daily lives of people in Wisconsin and of every state.
That's
So
right. I mean, we have, yeah. So the state constitution is known as one of plenary jurisdiction, which means the state government can do all things that are legitimate for a state government to do. And so the representatives in the legislature are exceedingly important, because they can affect people's lives in a much broader way than the federal government.
I think Janet Protasiewicz's campaign allies, they put up a bunch of ads that have alleged that, you you even if it were fully true, and I know the story is, I know the background of everything that, or I know what really actually happened, political ads being what they are.
Mm.
But alleging that it was a problem for you to provide to be a part of anybody's criminal defense. Like a
Right.
defendant in this country doesn't have a right to a criminal defense, even though the misrepresentation for that particular case, everybody knows. Um, but then there was another case where they were talking about recusal, non-recusal, and things of that nature. So I'd like to hear it from the horse's mouth, just your take on that
Yeah.
particular case. But then the irony, I think, right, falls back into like a lot of the cases that she has had, where she has either provided little to no penalty for people that are convicted of violent things such as domestic
That's right.
assault, that
That's
later resulted in a case where that same defendant in a prior case actually committed murder.
Yeah.
So the the dichotomy of the way that the cases are being presented is stark on its own. But could you
Yeah.
address that one case that I was talking about?
Sure. The criminal case or the recusal case?
The recusal.
Yeah. So that one, I think you're probably referring to the Zignego case,
Yes.
And that addressed whether the Wisconsin Election Commission or the local clerks have the authority and the responsibility for cleaning up voter rolls. And so that came to the court before the April 2020 election. And I looked at that and I said, well, the resolution of that case could potentially affect an election in which I'm a candidate. And so I said, well, I certainly need to recuse myself from that case because it could affect something in which I had an interest. And so then the election came and it went, and then the case came back to us on a petition for review. And I looked at it again, and I thought, well, this no longer has the capability of affecting anything in which I have an interest, and so there's no need for recusal. And so I wrote a letter to each of the parties, and I explained the reason that I recused myself originally, and then I noted that that reason no longer obtains, and then I asked if they had any objection to my participation in the case, and there were no objections. So here's the thing. So when Janet says this has something to do with campaign contributions, she's just lying. But it's not a surprise because everything that she says about me is a lie. And that's shocking. I mean, I never thought I would be in a campaign in which literally everything my opponent says about me is a lie. But here it is, and that's what she's being making a practice of. But the really surprising thing about this is that it was such a sloppy lie. I mean, honest to Pete, if you're going to do a lie, put some effort into it. I mean, this is something that, anybody literally in the world could figure out just by a few taps on the keyboard on the internet. You can figure out that she's lying because everything that I did in that case is a matter of public record. And incidentally, everything that I did in each one of the attack ads that she has created is the truth is readily available on the internet. Now, just to make it easy for folks, we compiled all of that into a document and we posted it on our website, justicedanielkelly.com. So you'll see in the upper corner, well, towards the top, a little off to the right, there's a tab called Fact Check. You click on that, and that'll have a list of the lies that my opponent's been telling about me, and then we explain what the truth actually is. So, it's terrible that she lies so constantly, but it's disappointing that they're so sloppy.
Thanks for that. Yeah, and I agree. I think the army of fact checkers that exist in St. Croix County, they were all over this, and I'm pretty adept with the internet, but I struggled a little bit because I was actually waiting for the campaign to come out and say, no, this is not true, this is not true. But then some people, enterprising people in St. Croix County's Republican Party, they actually fired back a lot of this stuff, like the answers, like line and verse, right? And it was so quick that it was impressive to see that there are people out in the hinterlands here in the western part of the state that are aggressively looking to try to provide answers to
Yeah.
and clarification of different things that the
Well,
other campaign is doing.
and I'm so grateful for all of them. You sometimes wonder, are people going to care about finding out what's actually true? And to see the kind of rapidity with which people went out to look and then come out to explain to their friends and neighbors that Janet's just lying. Once again, she's lying, and explaining what the actual truth is. I'm so very grateful to them for that.
I think people could look at Janet Protasiewicz's campaign site, and if you look at the list of her supporters, from Mandela Barnes to Tony Evers to Josh Call, if you look at that list of people, irrespective of what I think are conflicts of interest between Supreme Court justices who are listed as supporters for her site, you can kind of get a pretty good vision about where her politics lie and how that will inform her decision making process. But
Yeah.
for everybody else's benefit, can you provide a bit more clarity? And I feel like this is almost a question you shouldn't have to ask, but I'm going to ask it anyway. A bit more clarity. What is at stake if your opponent wins?
Yeah. So that's a great question. So because she's a politician who dresses up like a judge, what's at stake is all of our laws. Um, when I say that the decision before us is the decision between the rule of law and the rule of Janet, and that's kind of a shorthand way of saying that what Janet proposes to do is to set herself above the law and dictate to the people of Wisconsin what liberties they can have and which they can't, what laws they can have and which they can't, because she's bringing a political commitment to an institution that is only supposed to be deciding legal questions. So if you go through all of her endorsements and all the politics that she talks about as she goes around the state, you can tell pretty clearly from that which laws are going to go down and which liberties are going to go down. But if you want to have an even more detailed version of that, you can look at some of the cases over the last 30 years or so in which there's been a vigorous dissent. And if Janet gets to the court, those issues will come back to the court. There will be organizations that will relitigate all those questions the Supreme Court has already answered. Things like Act 10, photo ID, right to work, school choice. You can go through all of those cases where there's been a vigorous dissent. And what will happen is if Janet makes it to the court, those dissents will become majority opinions and those laws will go away. So that's the risk of having a political person come and put on the black robe of a Supreme Court justice. She'll just walk through our statutes and decide which pieces she likes and which she doesn't.
You know, one final question before we close out. The nature of the Supreme Court in Wisconsin is that of an elected position.
Mhm.
Does it make sense? And I know you would have a potential interest in this question, so it's really purely hypothetical. But rather than elected Supreme Court justices, do you think that that's something that should model the federal and be appointed and approved of by the legislature
Yeah, that's a,
versus an elected position?
that's a great question. And there are trade-offs depending on which system you adopt. So with the one that we have right now, of course, what you see is the tendency for some to engage in political style campaigning, bringing up political ideology and what they think the laws ought to be and what they ought not to be, rather than what the job of the court actually is, which is what we talk about in my campaign. So that's a downside. And of course, all the money that comes in. Oh my goodness! So this is already the most expensive Supreme Court race in the history of the country, not
Yeah,
just Wisconsin.
widely reported. Yeah.
Yeah, indeed. So there's that aspect too. Now, I think the upside of an elected position like this is that at least I think it helps the members of the court to remember that they are public servants. They have bosses they are serving. It's the people of Wisconsin. And having regular elections, although they are long terms, this is a 10-year term, it reminds the jurists that they need to every once in a while go back to the people of Wisconsin and report to them on what they've done with the authority that they've borrowed from the people of Wisconsin. And so I think there's a lot of value in requiring public servants to go back to their bosses every once in a while and explain what they've done, which is one of the reasons why I've listed every single opinion I ever wrote as a Supreme Court justice on our campaign website, justicedanielkelly.com, because I understand this process as being my report to the people of Wisconsin of what I've done with the authority they loaned to me. Now, the federal system, that has some benefits because there's not a lot of dollars that get spent on that. There is not the tendency to engage in political campaigning, so there's more attention paid to what the function of the court actually is. But now you bring in the question of, all right, so then do you have regular elections or do you have lifetime appointment? Because in that case, if your job is dependent on the legislature approving of what you've done, in the confirmation process, well, then there's the risk that members of the court, as they reach the end of their term, they might start tailoring their decisions to what they think the legislature would like to hear rather than what the law actually requires, so that when they come up for confirmation again, that they would retain their position. So, and that's why we in the federal system why we have lifetime appointment, because it's important for the judiciary to be entirely independent of the legislature. So there's ups and there's other models that can be used to staff up the judiciary, but they're always trade-offs, right? There are no perfect solutions, just trade-offs. So, although I'm in the middle of just a brutal campaign, and boy, I got to tell you, I hate waking up every morning to find out what new lies my opponent's going to tell about me, and I just hate that process. But this might be the best process available to us because it does teach the jurists that they are servants, and it keeps them accountable to their bosses.
And I think no good idea, no good plan um, is valid without having gone through the torture chamber of sunlight.
That's right.
And as we've seen, as I have personally seen and witnessed and found out, the vast majority of what Janet Protasiewicz has to say is really to be fair, um, a gross exaggeration of fact. And to be more honest about it, I agree with you. I think a lot of what she says is outright fabrication.
Yeah.
So with that said, Justice Kelly, I want to tell you, I thank you so much. It's a highlight of my relatively short career to be able to have a person of your character. And in the interest of disclosure for my audience, you and I met at a Reagan reunion dinner in St. Croix County about 18 months ago,
Yeah, that's right.
and where you gave a talk about what your foundational principles and beliefs are, which mirror my own. And I don't have the legal acumen that you do, but it was a pleasure to be able to listen to you then and to have your time this morning on this very busy day as you get ready for your debate with Janet Protasiewicz. And I thank you so much for your time, and I wish you the best of the luck on April 4th.
Thank you so much, Mike. And I thank you for this opportunity. This has been a delightful conversation, as it was when we got together with the Reagan reunion. As you can probably tell, I love talking about our Constitution and the role of the court and what we do as jurists, as opposed to politicians. And so I appreciate you giving me this opportunity. Thank you.
Yep. Take care.
You too.
If you like the interview you just watched, join us on twitch.tv/the More Perfect Union for more constitutional and conservative views on politics in the United States. Like or subscribe our YouTube channel as well. Take care.